Calling to order the Village of Riverside Planning and Zoning Commission regular meeting for Monday, November 17th, 2025. Anne, could you please call the roll?
Sure. Commissioner Kirk?
Here.
Commissioner Miller? Here. Commissioner Matthews?
Here.
Commissioner Graham?
Here.
Commissioner Clarkson?
Here. Is there a motion to appoint me as temporary chair for this meeting?
So moved. Second.
Thank you.
We'll call the roll. Commissioner Kirk?
Aye.
Commissioner Miller? Aye. Commissioner Matthews?
Aye.
Commissioner Graham?
Aye.
Commissioner Clarkson?
Aye. Okay. Are there any other officials in attendance?
There are not.
All right. Let's see. We'll now move to approve the minutes from the last meeting. Is there a motion to approve the minutes from the October 22nd, 2025 meeting?
Move to approve the minutes.
Second.
Does anyone have any changes to the minutes? Seeing none. Anne, could you call the roll?
Sure. Commissioner Kirk?
Yes.
Commissioner Miller?
I wasn't here, but with the understanding that since I watched the video, I think the minutes are accurate, then I say aye.
Commissioner Matthews?
Aye.
Commissioner Graham?
Aye.
Commissioner Clarkson?
Aye. All right, after the vote, the motion was approved. Is there anyone present who would like to speak during this time about an item that is not on the agenda? Seeing none. Anne, would you like to provide the village board update?
Sure. So the trustees reviewed the vacation rental request that we'll discuss tonight and the commission's feedback. The majority of the trustees expressed support for allowing vacation rentals in residential districts in limited situations, specifically in residential dwelling units other than single-family homes, in which the owner's primary resident is a different unit in that same building. And just as a note, residential dwelling units other than single-family homes, that would include two-family, whether they are side-by-side or stacked on top of each other, townhomes, and multifamily buildings. And multifamily buildings is 3 or more units. And obviously, we'll discuss this more during old business.
Okay.
That's all I have.
Okay. That's all I have. So should we move to old business? No?
Sure, yeah, we don't need a motion to do that. We can just move on to old business.
Okay.
Move back to old business.
Yes,
Sorry, did I jump here?
you did not. You're fine.
Okay. So then we move on to new business?
Nope, you'll be under old business, which is our discussion item, vacation
Oh, I'm
rentals in the
sorry.
residential zoning districts. Yeah, we don't have new business tonight. It's
Okay,
because we
sorry.
previously discussed this.
There's no
Yeah.
question mark there, so I didn't know I was supposed to say it.
Sure. Okay.
Should we open the discussion regarding vacation rentals in residential zoning districts?
Yes, please.
Thank you.
I would like to give a little bit of exposition to you, and this may be some information you've already heard, but I know there's been some interest in this topic, and so for those who are watching tonight or going to watch the video later, I'd like to provide a little bit of background information. So the materials for this meeting are available on the village's website, and there are links embedded within the memo so that you can review that information. There is a list of all of the previous board and commission meetings when this topic was last discussed from 2015 to 2018, included in the November 6th board agenda. So if you'd like to review that for some background information, please refer to that. This discussion began with a citizen request asking for to allow vacation rentals in the residential districts. Currently, they are prohibited. So the board directed on August 7th the Planning and Zoning Commission to consider that. The commission did discuss this during our last meeting on October 22nd, and there was the commission's discussion was included in the meeting minutes, which are included in attachment B and also in a different part of this agenda. So if you want, I think that's a faithful summary of the discussion and the commission's comments. So if you want to review those are available to you. And then on November 6th, the board reviewed again the initial request that we received and the commission's feedback. And generally, the majority of the trustees express support for allowing vacation rentals in the districts, but in a very specific situation, and that is specifically anything other than single-family housing. So two-family, which again could be a side-by-side duplex or a stacked two-flat. It could be a townhouse, or it could be a multifamily building. Specifically in that case, if the owner must live in one of the other units, that was a board recommendation in that building, and they must be present during the duration of the vacation rental so that they're there on site to prevent any nuisances from occurring. In discussing that, they also reviewed some potential standards and made recommendations generally, and then for the board's further discussion, or the commission's further discussion, excuse me. So they said that in this case, vacation rentals in these situations should be approved by special use. And for the benefit of the public, the special use is a zoning process. So it's an additional approval that you'd have to get before you start using your property for that use. What you would do is apply, submit an application that would be reviewed by the Planning and Zoning Commission during public hearing. That would be discussed, and then a recommendation from the commission would go to the village board. The notification process for that application includes a publication of a legal ad in the newspaper, in the Landmark, posting a sign on the subject property, and then sending out mail notifications to all property owners within 250 feet of the property. So the idea is neighbors would be notified that an application has been made, and they would have the opportunity to attend the Planning and Zoning Commission meeting where this would be discussed, and then any subsequent board meetings. Of note is that all special uses are reviewed using the same set of criteria, and effectively, in a nutshell, that criteria is what negative impacts might this use have on adjacent properties. And if it's considered appropriate use for that property, then it would be granted a special use approval, and that would be an indefinite approval, indefinite zoning approval. So you wouldn't have to come each year to get that approval. It'd be a one-time approval. However, a vacation rental would need to be licensed each year. So just like a business license, you'd have to apply for a license. And if there are violations of that business license, the village has the option to issue citations and ultimately revoke the license if the property isn't compliant. So that would be the review process if we move forward with this change. So the neighbors would be notified if an application moves forward. They'd have the opportunity to comment, attend public meetings, and state either in support or against, or have questions about the use. That would be their opportunity to participate in that process. As one of these notes here, during the last discussion of this topic in the 2015 to 2018 range, when neighbors objected to the vacation rental that was operating, they said really they wish that there had been a larger notification, that the neighbors had been notified that this was moving forward. I think at that time it was approved as a by right use. So the neighbors didn't have to be notified at all to start operating as a vacation rental. But they said really even 250 feet wouldn't have been a big enough notification. They said we would like to be 500 feet. So staff did recommend that. The board didn't seem to have an objection to that. It seems like a fairly minimal issue, and the only addition would be, I think, postage costs. So just to take a review of that right now, I included in the packet 2 mailing lists to show a comparison. This is the property that's subject to the request on Berry Point Road. There's a 250-foot mailing list, so these properties would be notified if that property submitted an application for a special use. And there's the 500-foot notification. So all of these neighbors would be notified by a letter in the mail if they applied for a special use for a vacation rental. So those are the difference between the two. You can see we're picking up basically all the properties on those 2 blocks and a couple down here. So it's a good difference between the two. In terms of the other board discussion points, they said the owner, again, must live in a different unit in the same building. So obviously if you are the owner of a duplex, you would live as your primary residence would be the other half of that duplex, and you'd rent out the other half. They're not interested, the board was not interested in allowing partial rentals. They said you should rent the entire unit. So they stated there shouldn't be a limit on the number of guest rooms. Currently in the standards for vacation rentals, the limit is 2 guest rooms. But they said there should be some limit on the number of guests allowed. I think the current limit is 6. We've already just talked about this increased notification requirement for a special use application. And also, some communities use different caps effectively for vacation rentals. So there could be you could limit the entire number of vacation rentals in the community itself. You could say we're going to issue 15 vacation rental special uses tops, max. Some folks do a separation requirement, which is either by feet or by block. And I put together a couple of examples that we can review later, but those were the kind of the general recommendations that the board had. So based on that, I took the existing vacation rental standards that are in the municipal code and included that in the packet, and then included some changes that we need to make. So these are the page numbers for this attachment, and they list the different sections of the zoning code and municipal code that would need to be amended to make the changes that are recommended by the board. So the first is very simple. It's just our standard use table. And what we would add is under these residential zoning districts, we would add vacation rentals as a permitted use and specify that as a special use and refer to this section of the zoning code for further information. Another section of the zoning code is the definition of a vacation rental use. We would need to reword that because it's specifically now related to commercial uses. So we would want to specify that there's a difference between the commercial use and the residential use, and that they would not be located in single-family dwelling units. And that would again refer to this following section of the municipal code. So this is where this next section of the municipal code is where the main section regulating vacation rentals is currently. So aside from some minor changes to the definition of manager and things like that, we would have this change to the definition of vacation rental. This currently says it's specified to a commercial zoning district, which is the case. You can have a vacation rental currently in a commercial district. This would allow it also to say a dwelling unit located in basically a non-single family building in a residential zoning district. So that just broadens the definition to the point that the board wanted. And then this specifies that there are a limit on, that would remove the limitation on the number of guest rooms, which didn't seem to make a ton of sense. And please feel free to interrupt me at any point. If you want to discuss this, we can kind of hold till the end to go through each of these points individually. But if you don't have any comments, I'll continue.
I had one question about the approvals. Would that transfer when the property is sold?
That's in terms of a special use, it is specific, I believe, to the owner of that property.
Okay.
I'll double check on that, but I'm almost certain it's specific to the owner of that specific owner.
So then a new owner would have to.
That's correct, would reapply.
Okay, thank you.
This specifically states the vacation rental should not be located in single-family dwelling units, just to really drive home that point. And this differentiates the fact that currently what the code states is if you've got a unit in a commercial zoning district, you can rent out a part of that unit. Now, the board didn't give direction on changing anything related to the regulations for vacation rentals in commercial districts. So I didn't make any changes to those standards. I looked specifically at what the standards are for the residential zoning districts. So, and this is the direction we received from the board. For the units in those applicable buildings, the vacation rental's primary residence should be a different unit located in the same building, and that owner shall occupy their primary residence throughout the duration of the rental period.
If I could interrupt just for
Please.
a second. The definition of the structure itself, I'm curious why a coach house wasn't included in that definition, because that seems like the most logical kind of graceful extension of this.
And that's a question I want to ask you a little bit towards the end, but we can jump in
Okay.
right if you want.
No.
My intention was we received a couple of, and I appreciate you bringing that up. We received 2 letters this morning in support of allowing vacation rentals specifically for the Coonley Estate, which is one of our Frank Lloyd Wright designed houses, which is a single-family house. And so that, I think, is a separate issue that I'd like the commission's input on. I thought that we might go through this first and then discuss that, if that's.
Sure.
Okay.
I mean,
Okay.
One specific comment. just in the text, it says owners shall occupy their primary residence. It might be, if we're going to go down this path, to be very, very precise on what that means, shall occupy, which means they shall be on premises, basically, not just, yeah, it's my house, paying the mortgage. That's all. That's my comment on that.
No, I appreciate that. So to save a little bit on our legal expenses, I haven't run this by the village attorney at this point. This is draft language.
Okay.
So before the public hearing, the village attorney would review this, make sure everything's legally sound, and that, exactly to your point, what we mean by occupy is very specifically defined.
Okay.
Good question. Okay. And this is where I think we could add language about a separation requirement, if the commission is interested in recommending that. Again, that was just something that the board said they'd like the commission's input on it. It gets a little bit detailed when it comes to the maps. Hopefully these were clear. But basically what I was saying is, in this section, or proposed language in this section is, you can't have a new vacation rental license if there's an existing vacation rental license within, and then insert distance, feet of the property, or potentially we could have it by block if there's an existing vacation rental on the same block. Now, our blocks are kind of funnily shaped, so we'd have to define, kind of what a block is, but that's a possibility. And looking at the possibilities for that, I looked at where I thought it would be most likely to have, these vacation rental uses. So our request is located at 150, 152 Berry Point Road. And Ms. Bernardi is here today and can answer questions for you. This is her residence. It's a duplex, and we've got a couple other duplexes on that street. So just taking a look at this, just measuring, you can measure these in a couple different ways. You can measure like lot line to lot line, closest corner. I did front door to front door, but that's, we can take a look at the different options for that. But this gives you an idea of the front door distance between these two houses is a little less than 60 feet. I think that's 57 if you round up. And the distance front door to front door between these two, if you had a limit of 125 feet, for example, then either one of these could still be used as vacation rental. So assuming this is a licensed vacation rental, and we had a separation requirement of, say, 125 feet, then one of these two properties could be used, but they would not both be able to be used if, for example, a vacation rental license was issued to this property. It wouldn't meet the separation requirement from this one, if that makes any sense.
When you talk to an attorney, this was one of my, again, presuming you go down this road, this was one of my big concerns, is I wouldn't want the village to start approving this. And I don't know if one of those people could say, why am I not being allowed, and legally challenge this. I know nothing about this area of law or these separation agreements, but it seems to me like it could be deemed unfair to other property owners.
Sure. So legally, you can do this. There's separation requirements are allowed. And it's, so an example would be if you had, sometimes in some communities, there is a liquor store separation. And so basically it's kind of first come, first served. If you get your application and you're approved, and you had, for example, two strip malls next to each other, and there's a separation requirement where effectively you can have one liquor store between the two. Whoever gets there first gets their state license and is operating, they get it. And that's,
Okay, if this is like well settled, that's fine. It's just one of the red flags that occurred to me, that I wouldn't want the village, with marginal benefit to the village perhaps, then getting into some kind of a legal issue.
You can
down
have
the
a
line.
legal justification for a separation requirement, and we would work with the village attorney to make sure that that's written correctly for us.
And if they put them in at the same time, how was it decided which one gets it?
I think it's literally by when the
Like the minute whoever gets a
application-
piece
yeah.
of paper down first?
I think it's starting the process,
Okay.
yeah. So in any case, this is obviously a limited situation, but I'm just trying to, take a look at where this would be located. The rest of these properties are single-family homes, so they wouldn't be subject to this requirement. So if there was a desire to say, we only want one per block, right? Or we don't want one per block, we want, there would be a couple per block. In this very specific example, you need to consider that these are next to each other, effectively. So if you wanted to say, I think having 2 per block or 3 per block would be fine. You'd need to consider the separation requirements for these properties. Moving on.
Because people could feasibly rent both of them at the same time.
Well, the idea is basically if we had that would be the reason that you wouldn't want that folks have separation requirements.
Right.
Is they feel that either, if there's a lot of housing that's eligible for a vacation rental in a specific area, then a lot of folks might say, that's a great investment opportunity for me. Or I too want to own, it would be different people, obviously, because it has to be the owner's primary residence. But if you had, for example, and I'm not trying to pick on Ms. Bernardi, but if she had some friends who wanted to buy these 2 properties, if they were for sale as an investment property, and they were all going to run them as, vacation rentals. Now, again, there's a limitation of the number of days per year that they can be rented. Currently, that's 60 days per year.
So that means 305 days a year, they would be empty.
That's correct. Not be used as a vacation rental. Yep.
That's,
So if you found that you're, the sort of more seasonal vacation destination, a lot of folks in, tourist areas will do a long-term rent during the winter and then short-term rentals during the summer. You could also do that here if you had a 6-month, lease for someone who just needed a place, different housing for 6 months, and then you wanted to do the rest of the year vacation rentals, you could kind of break it up by that.
what is the Riverside policy on long-term rentals?
We don't regulate long-term rentals,
So
and
this
that's
property-
over 30 days or more.
Over 30 days or more. So this could be a rental
Yes.
duplex. This is
Yep.
a deliberate choice to make it a short-term rental.
Yes.
Okay,
Yep.
I understand.
Yep. So any housing, any single family or multifamily could be, rented out in the long term.
Got it.
Yep.
Let me ask a quick question, sort of a process question here. So the board, I guess relationship between us and the board asked our opinion, we
Yes.
gave our opinion.
Yes.
They ignored our opinion, and now they're asking us to reconsider these specifics. Are they directing us to update the planning, the zoning plan so that it can happen? Or, like, I guess I'm a little confused as to what they want from us, because they already asked our opinion.
Sure.
And we gave our opinion. I mean, I think it was pretty, not quite unanimous, but pretty close to unanimous. What are they asking us to do now? Like, are they asking us to reconsider our opinion, or are they saying, no, this is our opinion, it's gonna happen, you need to decide what it looks like?
Sure. So I think it's a little,
Sorry, I put it a little bit bluntly, but.
no, that's fine.
I think it's
So
the
I
right
think-
question to ask.
I think the original request was pretty broad, right? It was generally consider vacation rentals in the residential zoning districts. I think this is considered a more narrowly tailored question that we didn't, because we had kind of a broad discussion, we didn't get into the specifics of whether this specific idea would actually be, would be acceptable to the Planning and Zoning Commission. So the first idea is this a more palatable option, when given these parameters, right? So when given the parameters of it being limited to 2-family, townhouse, multifamily housing, where the owner lives in a different unit on the same property, so that they're present, which is not kind of what our current regulations are. The current regulations are, it has to be a primary residence, but you don't need to be there during the time that the rental is on. So kind of framing this a little bit more like a bed and breakfast style use, where the owner is present, as opposed to, I think like some of us might consider more of a short-term rental situation where you kind of show up, you get a door code, you're let in, but you don't ever see your host. The host would be nearby. So I think in this specific situation, I think that's the question is, one, is this an option that the commission would recommend? I think with the idea that the board is generally in favor of hearing what the commission's opinions are about the standards that would be acceptable. So I guess that's a second question is generally, is this an acceptable idea? And then 2, considering that the board supports the idea of exploring this, if you were to look at the standards that are laid out, what do you think about those standards as a way to achieve this?
Okay,
Yeah.
that
So feedback on the 2 parts, I
okay.
think. Yeah.
That helped clarify, thank you.
Yeah. So in any case, in looking at separation requirements, Again, if the commission thinks that we shouldn't have separation requirements at all, I'd like that feedback. If you think that there should be some limitation on the total number, but it doesn't need to be geographically specific, we can consider that. Or if there needs to be a geographical consideration, we can include that. I would point out that geographically, due to the limitations that have been proposed, there's not too many areas where you're going to have a high number of vacation rentals, just due to it being in a residential district, right? And then you have to consider the fact that it would need to be the type of building where the owner could occupy the other unit, or at least one other unit in the building. And that's also acceptable if you have a multifamily building to the HOA, to use one of those units as a vacation rental, which not all buildings would accept. So we have a number of multifamily buildings, for example, on Harlem, but those are owned by a management company, and those folks don't live in that building. So they wouldn't be eligible for this. So looking at that, it does limit the number of properties where this could potentially occur. So these properties on Berry Point are one example. Another area is this area on the southern side of East Burlington, and the northern side of East Quincy, between Cowley, and I believe that might be Delaplane, but I could be wrong. I might have forgotten my geography. So these clusters are mostly two-family units. And so taking a look here, if you're looking at a separation requirement, whether it's a measurement from property line to property line, or like I measured it from front door to front door, a separation requirement here may, depending on the size of it, affect the properties on this side of the street. So if you had, for example, in this case, this is a duplex. I'll kind of zoom in here. I use this as my example property. And if you've been down this side of the street, you may have a memory of seeing these. This is a brick, I'm not sure what architectural style it is, but a brick house that could be considered theoretically eligible for this if the owner owned both units and rented one out. So from here to here, if this property, which is also a two-flat, wanted to rent, it's 303 feet door to door on that one. This one is 429. So if you had a separation requirement of 300 feet, theoretically, you are not by having a rental here, you're not preventing people from renting over here. So that's the purpose of the measurements, is kind of thinking about, if you do want to have a separation requirement, who are you preventing from renting? This measurement here, that's why we've got 250 feet 250 feet measurements. This is a 250 foot measurement. This covers basically from roughly the center point of these to the other side is 250. So if you had a 250 foot separation and you happen to have someone get an application to operate here, you're effectively knocking out most of the available vacation rentals on that block. And then further down that block, it must have been Herbert that I was thinking of. The same principle applies. We've got some townhomes here, 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 and here. And you can see the effect of the different separation requirements. So I know that's a lot of specifics, given the fact that I don't know if you support having a separation requirement or what you'd like, but food for thought.
So you'd need to have a business license for vacation rental business
That's correct.
through the village,
That's correct.
and then you'd need to proactively renew that every year.
That's correct.
Otherwise, it would lapse.
Mm-hmm.
What's the cost of that, or do we have a cost for that?
So the cost of the business license would be, I think that's $100, and then we would be collecting basically an accommodations tax on top of that. The cost, and I'm glad you brought up the cost, because one of the things that it's important to note is that the cost of the special use application are paid for by the applicant. And because it's a quasi-legal process and there are attorney's fees, there's the mailing fees, there's staff time to prepare for both of the meetings and the ordinance that we would need to pass to approve this. What we ask for is an upfront deposit of $2,500, and we base that on the average cost to do a complete application so that we're kind of breaking even. Obviously, if we'll give money back if we don't use it, or we'll charge the applicant if we use more. But it's about $2,500, so it's not, you know, there is some initial fee they would need to pay. There would also need to be inspections of the property prior to occupying it by the building department and fire department to ensure safety. And then with the business license process, they would renew annually, and of course, we've had the same protections in that process that we do for vacation rentals as we do for other businesses. If there are violations or there's some reason why the license needs to be revoked or reconsidered, we can go through that standard process that's already in place.
Okay. And you said there would be a limit of 60 total days in any calendar year for the residential vacation rentals.
That's the current limit.
And
If
the commercial
the
then,
commission
okay.
wanted to discuss that, you know, that wasn't something that the board said that they wanted to change. There seemed to be general support for that number.
Okay.
But if the commission has a different recommendation, I'd like to hear it.
I just want to make sure, I didn't necessarily see it, but
Sure.
my eyes on it.
Yeah.
And then I had one other comment, or just discussing text. It references, or you referenced two-family,
Mhm.
and then I was just looking at the code, there's some reference to two-family under dwelling units in the definitions. There's a reference to multifamily dwelling units, and it says, this does not include two-family dwelling units as defined here in the code. Now, I only have a paper copy, but I don't know, is there a definition in our code of what a two-family dwelling unit is?
Yes.
Okay, and is that, can you tell, how is it defined? I mean, because obviously more than one family can live in a single-family home, so how are these two-family dwelling units identified by the village?
I can look up the definition. Sure, so I think the layman's term, or the layman's sense that you'd get out of it if you were to read the code is basically, I think it says something like two residential dwelling units that are adjoined, have a shared wall. I believe that's the definition, or a shared floor, possibly.
I'm just thinking you could have a large home and you could have, you know, two families living there, related families or whatever, and they could have separate kitchen facilities and all the rest, and they could say, well, it's a two-family dwelling unit. So would somehow the village identify if someone came in and say, well, this is not what we were thinking of when we
Sure.
said a two-family unit. We
Sure.
meant a duplex, or we meant, you know, two adjacent townhomes or whatever.
Yeah, so there we've got the two-family is the building that's designed for occupancy by two separate and distinct families. They can be situated either vertically or horizontally, but each shall have its own individual exterior entrance. And so that would be, if someone came to us and said, hey, you know, because a lot of folks will have a kitchen in the basement or something, you know, for parties or whatever. If they came to us and said, no, we're a two-family unit, we would go through a definition, you know, and say, well, you know, you don't have an individual exterior exit. And we would say, you know, that this house was designed as a single-family home. You just happen to put a kitchen in the basement, and they can always appeal our interpretation to the village board.
That's just one of my concerns, that
Sure.
doesn't sneak into other large homes, that maybe you have parents and then they have their children come and they
Sure.
live in a part of their house, and maybe they even build a separate unit, but it wasn't designed, and then all of a sudden that's a
Sure.
rental unit and the neighbors don't expect it. So there's just kind of leaking in of things like that I'm concerned about.
Sure. I think, to me, this seems like a clear definition. Our interpretation is going to be, it's going to hew to the definition that it's not designed that way. You might have done some interior renovations. You may be using it to have extended family live there, but it's not a two-family
Okay.
unit.
Just maybe
Um,
something
yeah.
to flag for the attorney when you do get
Sure.
attorney review.
Yeah, we'll make sure that we review all the legal portions of this. So that's the section on separation requirements. Let's see, this is, I think, more boilerplate, just trying to get the code in line with what it should say, and a couple of minor changes there. Okay. This is in line with what the board recommended. We did remove a couple of standards that seemed a little bit too onerous about how frequently the linens need to be changed and that they need to clean the kitchen. I think, you know, we'll just say it needs to be clean and sanitary, and hopefully that'll cover that, because I don't think we're going to actually be
Check.
enforcing that actively. Okay. And as a note, there are a lot of requirements here. I'm kind of skipping through these just because there are a lot of requirements, and I'm happy to discuss any of them individually, but written into the current standards is that the village does have quiet hours of 10 o'clock to 8 a.m., and those need to be notified in the vacation rental. The current standards also say that regardless of occupancy, you can't use the vacation rental for special events, and it calls out weddings or any kind of gathering or party. And also, I think that you can't have outdoor use past 10 p.m. So during those quiet hours, you can't have outdoor use of of that area. This section gets into the number of guest rooms and the number of guests. So currently, the limit is 6 guests. One of the considerations that I mentioned and we went through separation requirement here, in the staff memo, is number of guests. So I suspect that because the number of guest rooms is currently limited to 2, it makes sense that you'd have a limit of 6 guests. That seems not unreasonable. However, if you have a 3-bedroom unit, that would, theoretically, if you had 2 people staying in each room, which a lot of times folks do, that doesn't leave room for like children who might stay. Especially if you've got small children, they might stay in the room with the parents. So one consideration was, I don't know if you want to increase the number of guests allowed in the unit. So one option would be if you've got, now we define in the code how big a guest room is. And that would be part of our application and review process. When someone comes for a special use, we'd say, all right, well, let's see a floor plan. Let's see how many rooms you have. Let's make sure that the rooms are an adequate size. Because there's a minimum size requirement for guest rooms here.
I just saw it's like 70.
Yeah, 70 square feet for one person. If you want to have 2 people in the room, you've got to have an additional 50 square feet for each occupant that you're going to have in the room to make it habitable. And you can't use kitchens or things like that to make up part of that space or closets. So part of the review process would be determining what the occupancy is. And then, if the commission recommends limiting, so we have, it's 2 per guest room, and their children 12 and under, but a limit of 6 total. So I don't know if if you all have any interest in increasing the total guest limit.
I don't have an interest in increasing that. I think where I'm hung up, and I can't decide where to give this comment, so I'm just going to give it now, is you're going to have to zoom out, so hang with me here. I think that the idea that a home in a beautiful neighborhood like Riverside would be occupied 60 days out of 365 at a time when there is such a massive housing crisis in this country is really hard for me to swallow. And I know that Riverside is very small and that we are not going to make a dent in the nationwide housing crisis, but we are a village that has 100% solar because we think we're going to make a difference in that way. And by making this a short-term rental and by facilitating more short-term rentals, we are taking lovely homes off of the market for families. I can't, it's really hard for me to get on board with that. And if we are going to do it, which I think the board would like us to do, then I think we need to make it as few of them as possible, because those are fewer families that will come live here, and those are fewer families whose kids will go to school here, and those are people who will just roll through. And I if you haven't bought a house lately, I think people might lose track of that. And so again, I know it's a very small slice of life here, but that's where I'm stuck.
I think that's a very valid point. And also by focusing this only on the multifamily units, we're removing the most affordable units.
They are the most
from
affordable
access
units.
Coming into the village.
And the expressed desire for the short-term rental is because they're more revenue generating than a long-term rental. It says that in the application. So I also think that it's exactly proving my point that we are taking the most affordable units in our village and giving them to people who can afford to stay here for a couple of days.
Well, I think many of the separation requirements and all the rest, and just the number of existing units that could satisfy these requirements are not going to mean, if we adhere to those, that you're going to have, I don't know, more than 10, 20 units that
20 units?
and if someone who's purchased the property chooses to, they think they can make more money than reselling it as a single-family home, then they can do that, or renting out as a long-term rental, they can do that. I mean,
They can,
Yes.
but my point is that as a village, we have decided that using renewable energy is important, and that is a stance that even though it is more expensive, that we decide on behalf of the village, and you have to opt out of solar. And so I think if we had, so that's 10, if we had 10 units in the village, that's 10 families of up to 6 to 8 people who don't live in Riverside full-time. And so I think if we're going, and then I see you, Commissioner Matthews, I think if this is what we're going to do, we need to make it as hard as possible to take affordable units off of short-term rental lists and availability.
I'm sorry, I just got a quick procedural question. Since we're kind of embarking on discussion now, should we be allowing public comment?
I would encourage public comment. And I apologize, I should have given pause to ask if you wanted to discuss further, but Ms. Bernardi, who's made the request, is here, and is available to
Yeah.
speak, and I think interested in speaking.
Yes, I think anyone
Yeah.
who's speaking should probably, before we start
No.
going down this road, it might make
Thank you.
sense to listen to people.
It's not on my agenda.
Would you like to speak about your application, or would you like to wait until later?
Whatever you prefer. I have some few short notes to say.
If you would, yeah, but if you could make them from the podium, so we can pick it up on the audio, thank you. Oh,
Does she have to be sworn in?
I know, we don't need to swear you
Okay.
in, it's not a public hearing, but if you wouldn't mind repeating your name for the record.
Oh,
We all
yes,
know
of
you.
course.
Yes, thank you.
It's right here. My name is Maria Bernardi, and as we've learned, I live on Berry Point Road, which, by the way, is a pretty busy street. It's not like I have kids playing ball in the street or anything, so that is a consideration to be aware of. But I was raised, just quick about me, I was raised at 12th Avenue and Roosevelt Road, not far from here. And Riverside has always been special to me. And the fact that I now own a home in Riverside is also, makes me extremely proud. And I really believe what I'm proposing here will not affect the standard of living in Riverside. Of course, if you didn't regulate it and you allowed an STR on every corner, that would affect things. But I think the village is being thoughtful in trying to reinstate the option of having vacation rentals. And I want to keep Riverside special. That's the whole point. So I want to share how special Riverside is. I know there's many people that have interest in coming to visit us. I wasn't at the previous zoning meeting, but I did want to differentiate. There seemed to be a question about that there's Airbnbs are allowed, B&Bs, bed and breakfasts are allowed downtown, and there's been no requests for them. And I just wanted to differentiate that a B&B is totally different because you're sharing the living quarters with the host, and you don't have your own privacy. And the appeal of an STR, colloquial known as an Airbnb, is your own privacy, your own kitchen, you're an immersive experience. And that actually the request for that has grown over the years. In the 8 years since there was the debacle here, they've gone from 8% of lodging in the States to almost 15% of lodging. So, and conversely, bed and breakfast has gone down. So people enjoy the experience. I know it is your job and my contribution to make this not infringing on Riverside's other residents. And I understand that, and I just want you to know that I do appreciate that. But I've been here almost 4 years now, and I've had many conversations from locals that say, I wish there was some place where my family could stay when they come to visit. And that's something that I would be facilitating, and I think a very big boon to the village. Holidays, Riverside events, people want to come in. I had a friend that came in for the stroll. I know people come in from out of town for many of our events, the hop stop. And it would be nice to be able to stay over and really enjoy Riverside, spend some of their money here, go to our restaurants, go to Riverside Foods, and that's what I see this could facilitate. Also, for the longer-term rental and STR, there is the consideration of folks that have construction being done to their home and they need to move out for 2 or 3 weeks. And they would, and I've personally, I'm a realtor also. I should have said that. And I personally had that request for, my house is going to be upside down for 3 weeks. I don't want to go to the roadway inn. So this is where I see the benefit to the locals. Also, we get some requests from history aficionados about what Riverside is all about, and that's who I want to serve. And that's how I would try to present the STR, and not for frat parties like what seemed to have happened here before I came here. What happened on Michaud Road is really not pertinent because it would never happen again, and that's certainly not how I see my rental to be going. So the question at hand is obviously putting STRs in the residential neighborhoods, and whether it infringes on your neighbors depends entirely on the quality of the host and the guests. And my job as the host would be to try and ensure that I receive the best guests possible. That can be facilitated by limiting occupancy, by the rules and regulations from the village. I would not offer any exterior availability, no yard parties. I don't think it's necessary. I have plenty of parking. I have a 3-car garage and a space for 2 more cars, so it wouldn't be an issue in my instance. It's part of the reason I like the idea. And when you market these, the way you pick your words will grab who comes to visit with you. So if you say things like, the overly attentive owner lives right next door, there are people who will say, I don't want to go there. And those are the people we don't want. So there are ways to subtly try to control having a better clientele than I think we had here with the debacle. I just believe that we can make this work. And as I said, I'm not interested in changing the standard of living, and I don't think it would be. There is such a need for friends and family housing. As I said, I've gotten that request. I was at an event, as an example, at the Coonley Estate. We talked about the Coonley, the Frank Lloyd Wright Coonley home. These people came from LA and New York to visit, and one of them said to me, yes, the first designed community outside of a major city. This is such a great town. We really would love to see the whole town and stay in town. And that's what I would like to try and feed. We couldn't accommodate them. They had to stay downtown. Obviously, there was no way in the city, in the village, that they could stay. So that's the kind of thing that I'm hoping to facilitate. I have spoken personally to my neighbors, my adjacent neighbors, and they have no issues. The one said, I saw it in the paper, it's a non-issue. He said, you're a good neighbor, I would expect that you'd be a good hostess. So that was nice to hear, and correct. We've talked about some of the positive elements. I just wanted to leave with that. The fact that friends and family would have a place to stay close, that you wouldn't have to drive. A lot of times, I know people say, oh, Oak Brook is good, but it's almost a half-hour away, and downtown Chicago also. Riverside is already, as you may know, highlighted in a lot of national travel sites. And so it would be nice for them to be able to, there's lovely, absolutely lovely reviews on the town and what we offer. It would be nice on a small scale, not suggesting we become a huge tourist town. I wouldn't want that either. But people who truly appreciate what we have to offer want to come and see it. And I think it would be a beautiful thing to allow that to happen. I'd like to be a hostess for all your friends and families and share our history with the world. I think Riverside is approaching it properly this go-round to avoid ugly situations. And I hope you can find it in your hearts to allow this to happen, make my dream of hosting Riverside guests come true. Thank you. Do you have any questions for me before I go away, before I sit down?
I have a question. Have you done long-term rentals of your?
Oh, I have. Well, I didn't mention that, did I? I've done this before. I lived downtown for many years, and I had two different rentals, short-term rentals in two different buildings. So I do have experience. I know what to look for. I know how to handle them. I'm not a novice, or this is not a whim. So yes, thank you.
Oh, I was just asking, for you currently live in a duplex.
I have, oh, I'm sorry.
Have you used the one half for any long-term rentals? since
I
you
have a
lived in
long-term
Riverside?
rental in there right now.
Okay, all right. And you would intend as well, so short-term rentals to continue, long-term
I'm sorry?
rentals? You would intend to continue your long-term rentals and mix in the short-term rentals?
No.
Oh, you would not? You'd only do the
I
short-term
would
rentals?
potentially do a longer-term winter rental if the village saw fit. But no, my intent is for it to be a short-term rental unit as much as
Limited
the,
to 60 days
as
total
much
in the
as the village
calendar? And you
allows.
would-
60 days
Okay.
is a little restrictive. I would love to see it more. It has to be economically viable for it to take place. And with 60 days, I'm trying to do the math and I can't, but 60 days, it would be difficult to keep the cost down of the unit.
That's why I was wondering if you'd mix in a long-term rental, like someone
Well,
who's,
again,
like waiting for their house to be
Perhaps every
moved
year
out.
would be different.
Yeah.
And, every situation would be different, so I can't
Okay.
really answer that
Okay,
directly,
okay, thank you.
but it's possible.
Maria, can I ask you how many bedrooms you have in your?
I have it's three bedrooms.
Okay.
Personally, I wouldn't want more than 6 people, and I would like to actually try and cap it at 5.
Okay.
And that's just, I haven't decided everything because it's all hinging on you guys, of course. So there are some still unanswered questions that I even have with how I would move forward. So, but I do know I wouldn't want more than 6. Okay. Thank you, guys. Thank you for taking the time to deal with this. I appreciate it.
Thank you. Commissioner Clarkson, we do have one other guest in the audience if we want to invite. Would you like to speak? Don't feel pressured to if you don't want to. Okay.
So my name is Cecilia Quintero. I am a homeowner here in Riverside. I don't think that there is much to say that I think Ms. Clarkson and Mr. Kirk haven't already said. I mean, I really implore the committee to think who would truly benefit from this change. I think just based off of the comments the public comment, which I just heard previously by Ms. Maria. I forget your last name, I'm so sorry. I do not see any positive or benefit to the Riverside community by proceeding. I mean, we are in unprecedented times, and I hate saying that because it's just true. And to think that you would be taking away long-term housing from potentially up to 20 families for the benefit of just so few, I truly cannot I can't see any benefit to this. I don't. I see more detriment to the beautiful community in which we all live in. So that's my opinion. Thanks.
Are there any other public comments or discussion?
So we have, I would recommend that we have because it's kind of a two-part question
Okay.
that the board has asked, right? And we kind of discussed the general, and gotten some general comments. Generally, if the commission feels that allowing vacation rentals in the specific instance that the board requested comment on would be appropriate. So that would be, again, a unit in a multifamily building, that the owner lives in the other unit, is present during the vacation rental, limited to 60 calendar days per year, with the conditions that we've talked about. And I can review some of those, and I kind of breeze through some of the conditions, because there are a lot of conditions, but Ms. Bernardi mentioned parking. The code already states that you have to have adequate on-site parking, or you have to provide for off-site parking in your application. So, and we can, get into the details later, but basically, given those parameters, if we can get feedback from the commission generally on that idea, and then given the fact that the board would like to know, what conditions would be acceptable, to kind of get your feedback on that. And somewhere mixed in there, and I'm not sure exactly where to put it, it could be a caveat to, or a part B to the first question, is would this be appropriate for some properties, for some single-family properties, based on the letters of support that we received. So we received, and I included in the packet today to amend 2 letters of support to allow short-term or vacation rentals, in the single-family, some single-family houses. And this specifically came from the owners of the Coonley estate. A thought that I had is that when we reviewed and allowed and landmarked coach houses can be used as an accessory dwelling unit, in zoning terms meaning a second house, effectively. So I know when that was discussed back in the early 2000s, there had been a prohibition on having an accessory dwelling unit on single-family properties. That still exists, with the exception that if you have a landmarked coach house, you can use that as an accessory dwelling unit. And the idea being that it was already set up as a coach house. It had, living facilities, and in the past, a lot of folks did rent those out to help pay for the upkeep of, our older houses. And that was an incentive to have the property landmarked. And the idea was that would preserve that property. It would provide some income for the folks who are trying to, pay the bills of maintaining an expensive old house, and, use a traditionally it had been used as a residence. So that would be in keeping with that. It could be, and I haven't spoken with the village attorney about this legally, it could be an idea to allow landmark properties to be able to have a vacation rental. If they have if they have a coach house, which currently you could use it, if it's a landmark coach house, it can be used as a long-term rental. It doesn't need to be rented out, but it can be occupied. But if you wanted to rent it out, you could. An idea might be to either allow it in the house, as in the case of the Coonley house, or in the case of a property with a landmarked coach house, to allow that to be used as a vacation rental. So that's another point of discussion for the commission. And I think I would expect that the board would want the commission's reaction to these letters that we've received, and to provide some input on that point, even though it wasn't a board discussion point.
So the letters from the 2 people who currently own part of the Coonley estate,
That's correct.
they do not have coach houses. So I read the letter, I thought it was they didn't really come, it wasn't very obvious in reading the letter that they were asking for permission themselves to have someone. It was like very subtly done. So we have no idea how they would accommodate these people, if they would have a separate living area or anything else. So it's very hard for me to suggest that would be okay.
So given I appreciate that. I would recommend we discuss what the board laid out first, the question 1, and then question 2 would be, given our recent requests, would there be any level of acceptability or some sort of limitation of allowing that? Is it because it's a landmarked house, which it is, where you might have some interest in tourism, where you don't necessarily want to have a bed and breakfast. You know, you don't necessarily want to provide breakfast to folks, but the house is large and you can provide them with a living space. Would that be acceptable in a landmarked house or a landmarked coach house? That's kind of question 2. And then question 3 is, given those, you know, possibilities, what conditions would be acceptable?
And there would be conditions for number 1 and number 2, or they could,
Presumably, we would
They
need
would
to
be
talk
sep-
about conditions for both.
Separate.
And I'm sure some of those would be overlapping. So returning to what the board originally asked, we did get some feedback from a couple of the commissioners, but if Commissioner Graham and Commissioner Miller and Commissioner Matthews want to speak directly to the first question, we can get that feedback.
The first question being the separation requirement, or,
I apologize. But generally speaking,
yeah,
given the fact that the board asked the commission to reconsider a very specific, a narrow
yeah.
idea of vacation rentals,
Mhm.
that is limited to multifamily buildings with the owner living in a
Mhm.
different unit and the owner present during the rental, would that be acceptable? Would that be an acceptable use in the residential districts?
Yeah. I struggle a little bit because I feel like I'm in the minority in that I'm pretty supportive. I'm pretty supportive of this. I mean, I feel like there are enough restrictions contemplated that from a kind of a regulations perspective, this will never be a runaway problem. And you know, I struggle specifically trying to balance kind of the property owner's rights with what's good for the whole community. And yeah, an out of hand, frat house is not what any of us want, but the way this is contemplated, it's far from that, right? And I just don't see the prohibiting it other than regulating it out of possibility. I don't think that's the way to go. I'm supportive of it.
So my opinion has not changed since the last meeting. I mean, I'm sympathetic. I mean, it's not, in theory, the idea of, allowing property owners to do what they want when they're in this very specific scenario of the, we'll just call it a duplex for lack of a better term, where you have a separate unit that you could rent out. But what I keep coming back to is, when this was previously discussed, there were over 300 signatures on a petition about the previous B&B. Now, I know it's not going to be the same thing, and everyone says, oh, this won't be, it'll be different because it'll be smaller, and it'll be someone living on site and all that, but it's still an issue. People were against this when this first came up. The second issue I come to is that I think as a resident, you have the expectation that you're not going to have, for lack of a better term, a transient community in your neighborhood, possibly next door to you. And I don't use that in a pejorative sense, transient. I just mean you're going to have people in and out on a fairly consistent basis, even at 60 days a year. That could be every weekend, every single weekend. You could see
Right.
new people coming in and out. And you take people as you find them, right? For some residents, they may not care. Other residents can be super, concerned about, they won't let their kids out to play if there's a strange car went down the street 2 hours ago, right? I mean, people are different. But you have to respect that. And so I think those concerns from residents, and I'm going to state that none of these residents were here to express those concerns, which I think is unfortunate because people knew about this meeting, and if they were concerned about this, they should have shown up. So I will, say that. One other thing, and I hadn't thought about this until tonight, until our acting chairperson and our other guests brought this up, is that this is at a certain level, you are cutting down on the amount of people who can live in the community when a certain amount of homes are rental only. I don't think that's a great thing. It's not really my primary concern, but I think it's something that should kind of be on our radar. And then I guess I have a couple questions. Is there anything to prevent someone from doing a new build and turning it into a duplex? Are there zoning codes that say you can only build single-family homes in certain areas? Or could I buy, like, say, a relatively cheap property and duplex it with the intent of doing this, provided that there was room to do it and everything else that was in, that we decide is there? Would that be possible?
Sure, it depends on the zoning district. So the R1A district, which is our largest zoning district, it's single-family only.
Okay,
So you would not be able to do, for example, there's an empty lot, and I think on Lionel, you would not be able to build a duplex on that lot. So there are zoning districts, R2, R3, R4, where you can build a new two-family unit.
okay. So what we're basically saying is that the areas with the most expensive homes and presumably the wealthiest residents will not have to deal with this because you can't build there unless they're already there. And I know what that sounds like, but I mean, it is what it is, right? I mean, if I wanted to build something, I couldn't do it on Scottswood, but I could do it somewhere else if it was approved.
Yes, you could build a two-family, yeah.
And then with respect to, townhomes were included in this. How does that work? Because a townhome, it could be, I grew up in a townhome on Des Plaines, and there were 8 units in it, right? I think 8, in the 2900 block, there was 8 different separate units. Could one person buy that entire townhome, live in one unit, and then rent out the other 7 units? Would that be something they could do?
Sure, so that's up to whatever regulations you want to put in place. So that would be a
Okay.
consideration for the separation requirement.
So that can be addressed
Because
with
that's part
Yep.
of
that, okay,
separation.
okay.
Okay.
I mean, I think we still need to vote on this because the board has decided they want to do this and they want us to look at the ordinance. I don't think there's,
Yes.
What I would ask is the commissioner's response to that first question, which you've given, and ask all the commissioners, what's your input on the first question? Given the fact that there's been a more specific request from Commissioner Miller, I don't know, did you give us feedback on that?
I could just recap what I'm thinking right now.
Sure.
So what is the first request? Is it just their list of restrictions? Are those good ones?
The request I was making is if you can provide feedback on generally,
Just feedback.
feedback on this, basically given the more tailored request
Right.
that the board said that they had support for.
Did like 6 bullet points that
Right.
they
Okay, well, let me
Back
just,
to us with, would we agree, is it appropriate to move forward with these 6 bullet points?
so there are 6 bullet points. Okay.
On page 14.
So at the last meeting, which I viewed, I was not supportive of this proposal. As I've thought about it a little bit more with these many restrictions on this, it's certainly possible we'll end up with the same situation we have now where we approve something and no one does it, except maybe Ms. Bernardi, because we have so many restrictions. I would be neutral, okay with moving forward since the board is requesting this with the many restrictions that are being imposed on this. An additional restriction, and that includes a separation requirement to limit the number of units, because I think if we're going to go down this route, we should have, a few test cases, basically. And to further that, it may be, if it's possible, I would recommend also having a limited number of special use licenses that would be granted, say, in the first year, which probably will not be a problem. Maybe the first 5 years, or whatever, or 1 or 2 per year, or some kind of limit, so that all of a sudden we don't have 10 big STRs, on, wherever area, in the R4 district or the R2 district or whatever. I would just want to comment, as I asked Ms. Bernardi about the long-term rental, since the village does not limit those at all, there could be, I think there is a desire for long-term rentals for, say, people moving into the village or having their houses being worked on or whatever. Just anecdotally, I think that's not being met, and I think, but my point, I guess, is just that it seems to me someone could do an STR and continue doing their long-term rentals, and you'd have the same issue with taking, living space away from someone by allowing property owners to do long-term rentals, but the market requires that. So I think that's a good thing to continue that. I think the other comments I made just about the two-family and making sure that's very clear. And then the other element that I would like to be very clear on as you go forward in this is the enforcement part of this. I would like to be very clear who is responsible for, in the village, who is responsible for enforcement. If neighbors have issues, who do they go to? And not just a Riverside response thing. And a lot of neighbors do not like calling the police over, someone's a bit loud or something. I would want it to be very clear how the village would go forward with enforcement if there are issues, and how residents could tap into that enforcement. Is it going to be the building inspector? Is it going to be a dedicated police officer who's going to respond to these, all the rest? Because I think that's where sort of our past experience fell down, is a lack of enforcement.
And who pays for that enforcement?
Yeah. So I think that is an important element of this whole process. The fact that you'd have to have a business license that, is only renewable every year, that's good, as long as there's a way that if issues arise, those are actually documented with the village. And that requires an easy process for people who have issues. And I do not support the issue of, again, because I want this limited, I would not support right now the idea of allowing this in coach houses or in single-family homes, even large single-family homes. I would want, if this experiment goes forward, to have this done, and then perhaps in the future, the village could expand it into coach houses. I think those are all my comments.
Okay, I agree. Okay, so our general consensus, what I've heard is Commissioner Graham is generally in favor of the proposal originally presented by the board.
Correct.
Is that correct?
Correct.
Commissioner Matthews is opposed.
Correct.
Commissioner Clarkson is opposed.
I mean, what I don't want to happen is for us to oppose it, and then the village trustees, which happened at my very first meeting, is we made decisions about the dispensary, and then the trustees overturned it anyways. And so I feel like if it's sort of going to happen, I want us to be able to put as many restrictions on it as we can while it's still in our court. So if I need to be in favor of it to put all these requirements in it, then I am comfortable doing that.
Sure. You don't need to be in favor of it to recommend. If it, you can provide your recommendation, which is you're not in favor, and then say, but if the village board decides that they would like to move forward, here are the recommendations that we'd like to talk about. And that's kind of what I was going to try to get at, is the third question, is if in fact this does move forward and there's support among the village board for this, how would you like it to be? What are your recommended standards?
Yes,
Yep.
that part is,
Okay.
you're describing my thoughts accurately.
Okay, sure.
Thank you.
And Commissioner Kirk, you're generally, did I hear that you say you're opposed to the?
Generally opposed. Yeah.
Generally opposed, okay. Okay. I just want to be clear so that I provide a good rundown of your recommendations. In terms of, because it's kind of related to the generally should this be allowed, Commissioner Miller gave feedback about you generally would not support allowing these in single-family homes, even if they're landmarked, or
Yes, I
and
would.
landmarked coach houses. You'd be
Yes.
opposed to that?
Yes, I would
Okay.
be opposed to that.
Okay.
Again, because I think if those people need to develop income, they can do long-term rentals, which are totally unregulated, as opposed to people coming in and out on a, on a frequent basis.
Okay. Commissioner Kirk, can I ask for your opinion on that?
Yeah, I mean, I think I agree that if we, if the trustees are supportive of going forward in this, that providing the most restriction is going to be what I think most of the committee here would be supportive of. So,
Okay.
yeah, limiting it certainly.
Yeah. And just to be clear, the Board of Trustees did not ask for us to discuss that. We received the letter, so I just wanted to, in case the board had said, hey, we received these letters, what did the commission think about that? I wanted to provide some feedback on that idea.
I mean, if I could just make one further comment, when it comes down to it, if people apply for this and they have to get a special use permit, I don't know how that discussion will go, because you may have a area, you know, like Scotswood. I mean, it's so subjective as to, is this appropriate in this area or is this not appropriate in this area? It would seem to me that, you know, in a multifamily apartment building, it would be more appropriate, whereas perhaps in Scotswood, it would be less appropriate to have an STR. But other people could feel differently, so it's, I mean, there will be some limitation when we're going through a special use permit hearing. But again, it's making me think about the legal ramifications of opening this up, and if someone could, you know, come back who wanted to be litigious and say, you know, this doesn't make any sense, this is totally subjective. So those are just some thoughts.
I do think it's totally subjective to make an assumption, mostly from a place of privilege, that people who live closer to other people wouldn't mind having strangers in and out, but if you have a big yard and a big house, you do mind strangers. I think that just because people live in multi-units doesn't mean that they don't know their neighbors well and that they don't want to know the 7 families that circulate through them. And so I think that there is an element of privilege in that. I'm trying really hard to think about that because I do think that regardless of the size of home you have or how many people live in a square footage, like, you're allowed to have a say. And we can't make an assumption about people and what they might or may not like based on the house that they live in and who they want to be close to.
Yes, I agree with that. Neighbors are not always pleasant to each other. Whatever your living situation is, you could have a problematic neighbor.
Yeah. Yes.
And unfortunately, we don't get to choose that.
I just want to just touch briefly on the letters and the Coonley house. I don't even think we should take that up, frankly. I don't even think we should give an opinion. If the board wants to talk about including coach houses in this, let the board bring that up and ask us specifically, because that's a very different thing. You know, there are a number of landmark coach houses, and I'm not sure what Coonley is. Is it a coach house or is it a separate dwelling? Like what?
Yeah, I have no idea.
I mean, I think I took a tour there when I was a little kid, but that's a long, long time ago.
So
Is
this is from the owners of the main house?
Yeah, so there's a separate dwelling they're looking at, or they're looking at splitting the,
It was unclear to me whether they wanted to host folks in the main house or they wanted to have them in a guest area separate from the house.
yeah, I think without knowing more, it's kind of, I don't think we should have any opinion on that, but that's just me. I mean, you know, we could, I was supposed to talk about it generally, but, you know.
I was, just asking for a general opinion
yeah,
if, you know.
I mean, I get why, but, I mean, what we're facing now, I think is, again, for lack of a better term, duplexes or larger, or, you know, multiple family dwellings, and I think we should focus the discussion on that.
Would either of you like to give an opinion about the idea of a landmarked coach house or single-family home?
I mean, I would agree with Commissioner Matthews that it wasn't put to us to contemplate, so, you know, maybe we don't necessarily need to weigh in on it. You know, at the same time, the special use permit process and the notifications, et cetera, I feel like are going to address a lot of these concerns about neighbors having a voice in what goes on next to them. And so whether or not a specific coach house may or may not make sense, or the Coonley estate, if they carve out, if there's some corner of that property that could be carved out, you know, I feel like the public process will suss that out. I don't feel like, you know, we're in the position to dictate one way or another, and not let the affected property owner have their, you know, their due process to take in court.
I tend to agree with Commissioner Matthews and also Commissioner Miller that let's just see how the first step goes before we open up more for people.
Okay, fair enough. With general ideas about how you feel about the request, if the board wants to move forward, I just wanted to run through these criteria and get your feedback. And please interrupt me if I'm putting words in your mouth, or if you disagree, but I hear general support for If vacation rentals are allowed in multifamily in the residential districts, a special use should be required.
Yes.
Is that the general consensus? That the owner must live in a different unit in the same building and be on site during the rental period. Is there general consensus for that? Yes, okay. Should there be a limit on the number of guest rooms that can be offered?
Yeah, I think that's,
There is currently a limit of 2 guest rooms. So if we had a limitation, for example, if we had a person, Ms. Bernardi, just to use an example, said that she had 3 guest rooms in her unit. When we would review this as part of the special use application, we would say, well, there's a limitation on 2 guest rooms. So when you advertise this, you'd have to advertise 2 guest rooms and not offer the 3rd.
And
we
so
can-
they're suggesting we don't worry about guest rooms and we just worry about the number of guests.
That's correct.
Yes.
Yeah.
I'm okay with that.
my understanding, and you touched on this before, but I might not have been paying great attention at that point. So there is some kind of an occupancy limit that the village has for, you couldn't have an STR and have 20 people go and live in the duplex for 3 days, right? So that would be part of the licensing process, as a limitation on the bodies that could be legally allowed.
That is correct.
So that's, I think that, to me, that's adequate.
Okay. So currently, the limitation on guests is 6, and that includes children. We'll get back into that in a second, but I just want to touch on these. Should there be an increased notification for the special use application? Currently, it's 250 feet, and folks had recommended a 500 foot.
Yep.
Is that general support for that? Okay.
Yes.
And then, so we'll touch on guests and separation requirements, because these were listed here. So in
And then
term-
is it just, there would have to be a notice on the piece of property, right?
Yep, there's a
sign that
there's a
comes
sign
on.
posted on the property, in addition to the letters and the legal ad. In terms of the separation requirement, if the desire of the commission is to limit these effectively to, say, 1 per block, basically what we can do is take a look at what that distance will be, and I can come back to you and say, you know, this is gonna limit you to 1 per block effectively. If there is not a desire to have that, if there's a recognition that, you know, having a separation requirement, you know, for example, in this area. So basically, you've got rows of 2-family houses on 2 different streets, East Burlington, East Quincy, and depending on how you drop the separation requirements, you can kind of effectively have 1 for both of those streets. So if you put like a 500-foot separation requirement, and someone get a license here, that effectively eliminates all of these from having, from doing a vacation rental.
I'm less worried about that specific use case because the train tracks cut through it.
Okay.
Like, I feel like that, I don't know.
Okay. Is there, in the case of, let's see, the townhomes, now it seems somewhat unlikely to me that someone's gonna buy a townhome, reside in as their primary residence, and then buy another townhome in that building to rent it out as a short-term rental, but it's possible. Given the fact that this would be considered 1 building, do we wanna limit the number of short-term rentals to 1 per building if you've got a townhome? Or some other limitation?
I'm generally more supportive of this idea of a limit on the quantity as opposed to just a radius restriction.
In terms of location?
Is the radius restriction, by granting that first license, you preclude every other possible petitioner from
Right.
getting that license. And, you know, one, I just don't think from a property rights perspective that for this kind of a use case, I don't think that's a just way to go. But in that case, if the person who does get the license is a bad actor and not a good steward of Riverside or whatever, and it precludes somebody who could otherwise be a good sponsor or host of one of these units, for that reason, I don't like the radius restriction. But you know, I do think from a quantity perspective, whether it's community-wide or in the situation like Commissioner Matthews brought up with a building with X number of units, you don't want all but one of the units to be short-term rentals. I mean, I think that's certainly a reasonable restriction.
Are you proposing, you mean like a village-wide? Like we're only gonna allow 5 as opposed to being more like radius?
Well,
Like, is that kind of what you mean?
yes, I mean, in some absolute terms, and what is that number? I don't know.
Right.
Right.
Just guessing.
But also whether that's village-wide, but also kind of property-wide, right? In a case where there's 10 units in the building, you know, if there's 10 units allowed in the village and there's 10 units in the building, they don't necessarily need to be the same, right? You know, I could certainly see restricting the number of units in a single structure.
So you could have both. You could have a limit on the number of licenses issued within the village and a restriction that says you can have 1 short-term rental per building.
Yeah.
So I'm generally, I mean, quite sympathetic towards the property rights argument. My only concern here is that what I see happening, if you don't do the radius restriction, you could very easily end up, maybe not easily, but it's conceivable, you could end up with an area where is just very, very heavy on these units, right? You could have like this, you know, Quincy or Burlington are probably better examples, but if you don't say like, there can only be 1, you know, within X amount of feet, then you have no restrictions beyond saying we're only gonna issue, you know, 5 permits per year or something like that. And at a certain level, that has the same impact. And then, you know, if, you know, people grab them up on one street and then you can't have them anywhere else. I mean, that doesn't seem to fix it either. And I mean, of course, the problem is that Riverside, you can't do this by blocks because the blocks, we're not on a grid. You know, we're not on, you know, every block is an eighth of a mile. We just don't do that here. So it's really hard to say like, well, you know, because, you know, Cowley to Delaplane is a long block, right? You know, Evelyn Road is 1 house, so, but that's a block, so it's hard to, I'm not sure how to fix that beyond saying, first come, first served, and here's the radius. You know, you can't be within, there can only be 1 within,
Yeah.
you know.
I don't think we want a concentration.
No, that's something I'd really like to avoid.
And so I think
concentration.
without having sorry, I can't come up with the separation requirement, we could have a concentration. So I think we need a separation requirement. I think we need a village cap. Was there something else? There were like 3. I think that's it.
I support both of those. The only thing I'm struggling with is, as you mentioned, like with the railroad tracks, like let's say you have houses backing up to each other. Just because you have, you know, say someone on whatever street, if houses back up to each other, they have yards. You wouldn't necessarily want 2 houses that back directly up to each other, but by saying 500 feet,
What if we said?
you have 2 back, you know, the other street, it has no impact on parking or anything else. I'm not expressing myself, but I just can see situations where you would have maybe 500 feet separation, but 2 totally separate streets, and it wouldn't really impact anyone if you had 2 STRs. So I think the distance, the radius thing is just a little tricky. Definitely, though, not to have more than 1 and say it like that 8-unit townhome, definitely. You wouldn't.
Oh, that's right.
you
That's
know,
what I want.
people
And only
going in
1
and out.
per
Building.
multi-unit, 1 per multi-unit, a separation requirement, and a village cap.
Yeah.
I think those are the 3 things that we're talking about.
But if we have like an apartment or multifamily unit and you have, or like the Village Commons building, you know, I don't know how many units are in there. If there's 25, should there be only 1 in there? If there's an apartment building and you have 60 units, should there be only 1 in there? So there's just a
Right.
lot of.
But those are commercial districts, right? Then, like the new
Oh,
building
yeah,
that's going to
that's
go
right.
up is commercial.
Well, but
so
there's
those-
the R4, there's the R4, which has apartment or R3, that has a lot of apartment buildings in it.
Yeah.
Part R3.
The area over by the river that floods,
Mm-hmm.
like Kimbark and, I'm blanking on the other names, Groveland, and the other street that's between them.
We have condo buildings and apartment buildings
Yeah.
in that area, yeah.
And so I don't know how many units are in there. So anyway, I just think some combination of number per multifamily building and radius would be good, in my opinion. I just don't know what that would be.
I think we can write the separation requirements so that, for example, these opposite sides of the street, literally we can say, you know,
Reset
that they're
the-
separated by a railroad, you know, you wouldn't count that.
Okay.
But just to get an idea of how many houses apart they should be, just
I
in
mean,
theory.
could we include that both? Have like both a number of feet or a certain number of properties, whichever is further or something like that? So that,
We can try to do that. So just to get a sense of what would be acceptable, and then we can kind of write our way back from there.
Okay.
If we take a look there and we say, this, you know, let's use our example property, this 67 and 69, which are one building. You know, it sounds like probably having the next property over being a vacation rental, generally it sounds like it's probably not acceptable to the planning and zoning commissioners. I could be wrong. Don't let me put words in your mouth, but if we moved one property over, would that be acceptable? If there was one property between them, or one more property? So if you can give me that kind of feedback, then we can kind of figure out what that distance should be.
So if 167 and 169 were one of them, or so if 167 was a short-term rental, how
Yes.
close would we want the next one to be on that street?
Exactly.
Forgetting about the railroad tracks.
Yep, just in this row here, because these are all single-family across the
And
street.
those arrows point down at 250 feet from 167.
Yep, so this section from 167 to here is 250 feet.
Oh, okay.
And this here is 250 feet. So those are two sections starting at effectively the front door.
So that's interesting though, because then that brings up, like, let's say if you were to say, oh, no, actually it does, no, that makes sense. So if you were, because my inclination would be to go to 500 feet, not 250 feet, right? So what is this? Is that 250 feet from the house, or is it a total of 500 feet? Like, what's the,
From here to here
Yeah.
is 500. And you
Okay.
can barely see, and I apologize for not making this clear, but this segment from here to here, starting at the front door of 167
Yeah.
and going out, that's 250.
so, yeah, no, it's not you, it's me. I'm really bad at math and mathematical concepts. So what I would see would be like, I guess 1,000 feet then, right? Because that way you have a 500-foot buffer on either side of the house. As opposed to a 250-foot buffer.
Okay.
But to
Then
show I'm
what
not
about-
completely insane, I would absolutely say, don't worry about the railroad tracks. If a railroad tracks, there's only one in town that would do this, right? If it separates properties and it's only in this area,
That
then
would
they don't,
effectively
they do not
address
count
this.
for that figure. So, I mean, that's, I could see doing that. But I think otherwise, because that's really not a lot of houses. I mean, if you could then put up you know, if 167 is the Airbnb, and then you could put another one up at 141, you know,
Yes.
you know,
No.
that's pretty close.
No, that's single family.
Okay,
So
but-
that's outside.
yeah,
But
right.
I take your point, but
But you know what I
basically.
mean, you could put one up.
Yeah, I take your point, but basically your recommendation would be 1,000 feet, so that basically in this stretch here
Yeah.
of two-family, you could have one.
That
And
would
whoever
be-
got there first effectively
That would be
got
what
it.
I would recommend, yeah.
Okay.
And then would you apply that 500-foot radius in, all the way around, in front and back, everywhere? Or
For-
only along the block, along the street that the
Okay,
unit is
so-
located on?
I haven't thought that deeply about it, but I would apply it down the street on both sides of the street.
On both sides of that particular
Yeah.
street, but not
Yeah.
behind it?
Well, in this case, no, because the railroad tracks.
In another case where you had a back, two backyards back.
That's an interesting question. I don't know the answer to that at this
Yeah,
point.
it's hard to think.
Yeah, I mean, do you run a 1,000-foot line, you know, is that north, whatever, you know, directly, you know, towards, whatever the next street over from Burlington is, and does that impact those properties? I don't know the answer to that, but
And we-
certainly a line of 1,000 feet, both sides street.
Yeah, I agree with, on a street, that makes sense to have a different maybe line, because you're gonna have direct impacts from people going in and out of a unit and that kind of thing, as opposed to another street that's, you know.
So the preference
separated.
would be basically to not measure this way or this way, but to measure this way along the
Or-
street.
Or to measure, but not this, maybe the same, whatever it is, 500 or 1,000, maybe 250 or 300.
So
I
different
mean, a different
measurement.
measurement.
Okay.
So you wouldn't have like a house right across the street who is also an STR, or two doors down, or kitty corner, it's STR, but.
So theoretically, if this property right here were let me zoom in a little bit. If this were a two-family unit that was subject and they wanted to get a license, and this was also a two-family unit that wanted to get a license, there should be a separation so that you can't have a back-to-back.
Just from a practical, you know, impacts for the neighbors, I think that's true. Like 205, if that was also an STR, that would not have nearly the impact of, as if 268 or whatever, that one, yeah.
Well, yeah,
268 is an
yeah.
STR. And it's just a matter of, I don't know, maybe it's 150 feet. Anyway, something like that.
Okay.
And it should take us an attempt at it, Anne. I trust you.
Oh, yeah.
To write something. I think you kind of have an idea what we're saying.
As long as I understand what the goal is basically to not have back-to-back. Is that generally the consensus?
Yeah, we don't want
of the
backyards.
commission?
Really close.
You will definitely have a party if you have back-to-back backyards that touch each other.
Okay.
And then do you happen to know off the top of your head where all the townhomes are located in Riverside?
I know, I use these as an example, just because I thought it would be helpful for separation, but I haven't made a map of every potential location where these could be. But it sounds like that's gonna be necessary, is to kind of take a look and be able to draw, and come up with an appropriate measurement. And it could be that we have to make a measurement specific to different geographical areas in the village, so that we're not gonna have one single measurement. It's like, for this bound geographical area, here's how you do the separation requirement measurements. For this area, here's how you do them.
Yeah, I was gonna ask that, is there a way to identify
We can
every
divide them
single,
up.
yeah, you can do that. I know you'll never be able to identify owner occupied, that would be impossible, but you could identify all multifamily
Yep,
dwellings in Riverside and then go from there.
we can certainly do that.
Yeah.
That's, I mean, it's a little more detailed when it comes to writing the ordinance, but as long as, like I said, as long as we have a general idea of what the commission is recommending, which I'm hearing is basically one per building, with some sort of separation requirement, so that without consideration of, oh, this is gonna fail me now. It's the wrong page. Looking at something where the railroad separates, that basically there's a desire to have one short-term rental in this stretch. Is that correct, generally from the commission? You wouldn't want to have more than one?
Right.
Everyone in
I
agreement?
have no problem with having more than
Okay.
one. I'm sorry.
Okay. Sounds like 4 out of 5 of you would generally,
4 out of 5 dentists agree.
okay.
Yeah, density is, I'm for it, yes. Density is not what we want. It's not what I want.
Yeah.
Okay. Okay.
I mean, yeah, I don't know if the number should be 400 or 500 feet to the left and right. And
But to
that's
have
going to
a-
vary in the size of the lots, but maybe it
Yeah.
won't, because you're not going to have the duplexes and stuff on the larger lots, because if you have, yeah, I have no idea.
Okay, but the goal generally in this scenario
Generally
would
to
be to
reduce
have
density.
one, for 4 of the 5 of you, is to have one vacation rental in this area, not more than one.
Yes.
Okay.
Yes.
And then one over here would be acceptable, okay. And then in the case of our example in Berry Point, where we have the 3 duplexes, with the desired, because they're kind of facing each other, but still on the road, what I'm hearing of 5 of you would be to have one of these be a
Correct.
vacation rental, but
Yeah,
not
same
more than
concept,
one. Okay.
I think.
And Commissioner Graham, no
Yeah.
opinion, okay,
Yeah,
I disagree.
all right,
yeah.
okay.
Because
So
I really
that's-
think
that's
that's how
helpful.
developers would take over, right? That's how you get private equity to come in and they buy up the 3 houses and then they plant a 22-year-old in each of them to live, and then they rent out the other ones, right? Like, that's what happens with these big investment firms, is they buy in huge swaths of housing together, and that's how they build this density, and then they kind of manage them all together. And so I really think that density is something that we want to avoid.
Okay. Yeah, so basically when I present the, I think I've got enough information about the separation requirement to move forward on that. Let me go back to our considerations. So separation requirement we've covered. Number of guests. Now currently the limitation is 6, and that includes children. I know we have Miss Bernardi here who said that she's completely comfortable with having the limitation
She said
of
she
6
preferred
guests.
5.
Or fewer. I just want to see what the commission's input is. Do we think that we should keep the limitation on 6 guests? Do we think we should change that?
I think 6 is fine.
I think 6 is plenty.
I don't really have a sense of what the right number is. It should be not unlimited.
6 is fine with me.
Yeah, I mean, absent having an inventory of exactly how many bedrooms and units and exactly what would be affected, is 6 better than 8? Sure.
Okay.
I mean, maybe it should be 2 per official bedroom or something like that. I don't know.
Okay.
And then, and just to be clear, that's still gonna include children then, because that's gonna, or not include children, so you could,
No, it does include children.
So the limitation on 6 includes children?
But the age of a child is 12.
a limit of 6 guests would allow 2 adults in each bedroom to the 3-bedroom unit, but it would not include children who might sleep in a guest room with their parents.
That's correct.
So
So
it
the
just-
current restriction
Right.
is, it does say that you can have children stay in a guest room. You know, in addition to that, children under 12 aren't counted towards the total number that you can have in a guest room, based on the size of the guest room, right? So you've got, it says 70 square feet for one guest. It's got 50 to have 2 guests. But it says, well, if you have children, you don't need to count the size of the room.
I see.
But what it says is, you can have 6 total people regardless of age, 6 total,
Gotcha.
including children. So the thought was, well, you know, if you have someone who has, you know, 2 to 3, most of these units are gonna be 2 to 3 bedrooms. You know, if you have folks who wanna bring children, it could be that you have 2 adults and a kid for each room. And so that would bring you over the limit. That would bring you to, I think, 9 folks, if you had a 3-bedroom, instead of 6. So that's the consideration. Is everyone still comfortable with 6 as the
6
limit?
is fine with me.
6 is
Okay. Okay. We talked about the increased notification for special use applications. And the one thing I wanted to note, and this is mostly for the benefit of folks who might be watching the video who are less familiar with the zoning process, I did talk about the special use process before and special use permits. There's a standard set of criteria that the Planning and Zoning Commission and then the board use when reviewing the applications for a special use permit that are listed here. And so we would consider that when an application came in. The other thing is, that's important to note, is that the commission can recommend conditions for a special use permit, which the board can accept, amend, or reject, and the board can also recommend their own conditions. So if we did have an application come in and there was a concern specific to that property about the proposed use, the board can recommend or require a condition. So I appreciate all of your feedback. Is there anything that you think that we didn't capture in the discussion? And we reviewed quite a bit of this.
I don't think anybody thanked the guests for coming and sharing their opinions, so thank you to both of you for coming and sharing your opinions.
Yes, thank you.
And I would just reiterate to the board that we're very sensitive to, if this is going to move forward, that it be highly controlled and limited, you know, so that's all. That's what I think.
Okay. And was there a feeling from the commission, anyone have any idea what you might want to limit in terms of the total quantity of short-term rentals that are allowed in the village? I know that there was talk about having a cap on them.
I would start with 3.
Okay.
Frankly, I'd start with 1, but then that would appear to give favoritism to one.
Right.
So we don't want to do that. But yeah, I mean, limit, because I do think there's some concerns here. And again, I'm just going to reiterate these, and this is the last time I'll say it, but, you know, the board is forcing this on us because they're saying they heard us once, and now they're coming back and saying, well, we heard you, but we don't agree with you, so here it is again. You know, we want you to talk about this, and we talked about it. I'm still 100% against it. No offense, people are for it. I mean, it's, you know, we're all entitled to our own opinion, and I get that. I'm 100% against it, and I really think we need to be, you know, very clear, as Commissioner Miller said, that we want, you know, restrictions, and I think we really need to start out small, really small. So I say 3, for me, is the amount you would start with. You do 3, if this passes, it would be 3 licenses within the first year, and that's it. And then if it seems to work out okay, but I remind, you know, people need to be cognizant that there is potential for abuse here. People can start buying properties and turning them into these things. The private equity issue.
I'm telling you,
raised,
they're coming for everything.
Companies do that. There's areas, you know, in this country and in other countries where Airbnbs have destroyed the local economy. They've destroyed it. People can't afford to live there anymore. You know, people just buy homes and rent them out, and that's just, you know, people are commuting 100 miles to work in those areas. So just be really clear of that. And again, I just got to say this, it just kind of sticks in my gut a little bit that the the largest homes and presumably the wealthiest areas are essentially immune from all of this. I know there may be a few duplexes in those areas. I mean, Berry Point's a lovely street. There's a couple duplexes, I think, on Lawton. I don't know that there's any where others might be, but looking at these maps, these are all gonna be put on, it's gonna be Quincy and Burlington, which is where the lower priced homes are, and there's something about this that rubs me wrong. So, but that's it, I'll shut up.
I think the first 3 units should be next to current trustees' houses.
You made to bang the gavel. I agree that 3 sounds like a good number, and they can prove it. If it can be done responsibly, then prove it.
Okay.
I think 3 is a good number.
Okay.
I mean, certainly in the first year, maybe in the first 2 years, yeah.
Okay. In agreement? Okay. 3? Okay. Okay. Is there anything else is there anything else that we didn't cover? I know we talked about this extensively, and I appreciate all your input. All right. That's all I had for vacation rentals.
That's it?
Let's go back to the beginning.
Well, with me, I don't even know what I'm supposed to read next. So I'd close the discussion? No, you just want me to close the meeting?
Just with some information first, is that we have our next upcoming meeting, I'm just checking the date here, I believe is December 15th.
The
but I
next
think it
meeting
should-
will be on December 15th, yes.
Perfect.
I do have that.
We do have a meeting scheduled for December 15th, and that is an unusual, I believe that's us on a Monday, because I believe that was rescheduled also due to the holidays. Yes, that's a Monday. It's a Monday, December 15th, here in room 4.
Okay,
But that's the only other information I have.
thank you. And is
And
there a
then-
motion to adjourn?
So moved.
Second?
All right.
Okay.
The meeting
Now you
is.
have to call.
You say all in
Oh,
favor?
all in favor of closing the meeting?
Aye.
Aye.
Okay, any opposed?